Hello, everyone. Hope you don't mind the makeshift studio. Just coming to you from my office today. The lighting's a little less than perfect. Maybe the audio is too. But my goal is sincere. My goal is to help you regarding the midterm you recently took. I want to tell you what the answer key was, explain to you where you would have learned that information in case you didn't get it right, and then to help you guide your way through the material again, because the midterm is just the beginning. It's only 20% of your grade. The final exam is the kicker. So to the extent that you got any of these questions wrong, I want to give you some guidance as to what you might read, what you might review again from my past lectures, how you might better be prepared for the final exam. So that's what we've got going on. The midterm had 10 questions. I crossed one out, so that left 9 questions that we're going to grade. I crossed out number 2. So 9 out of 10 were graded. At least 2 of you received 9 out of 9. Got 100% in the exam. Congratulations on that. But at least 2 of you received 1 out of 9. You got a very poor score of 1 out of 9. So to the extent that that means I let you down, I apologize. Certainly it was my goal to educate you and educate you well. So let me show you where in our lectures and in our textbook you could have learned the information that was on the final exam. And that's my goal here. The final exam itself you can access on our class website, as you know, is flaconstitution.com. That's www.flaconstitution.com. And the answer key, as you can see on the screen right behind me here. So if you go to flaconstitution.com, you'll have a view of the screen. Let's get started. Let's start with question number 1. Question number 1 and question number 7 turned out to be the hardest in this exam, insofar as more people got the answer wrong than got it right on questions number 1 and 7. So let's take a really close look at questions 1 and 7, shall we? Here's question number 1. Question number 1, as you can see, when litigating issues arising out of Florida's Constitution, which of the following statements about Florida lawyer ethics and Florida judicial ethics are true? And where would you have obtained knowledge about Florida lawyer ethics and Florida judicial ethics insofar as they apply to the practice of constitutional law in Florida and practicing law under Florida's Constitution? Well, you would have learned it in a required reading in interpreting Florida's Constitution in that textbook. Indeed, chapters 2 and chapters 3 are parallel insofar as one begins with the discussion of judicial ethics as they apply to constitutional law. The other starts with the discussion of lawyer ethics as they apply to Florida constitutional law. So the answer here was in those prefaces. The correct answer was D, and D was the only statement that was true of the 5 choices. And D read as follows: the Code of Conduct for United States judges applies to all judges holding a judicial office created by Article 3 of the Constitution of the United States, except the justices of the Supreme Court of the United States. And this is something we talked about in our lecture. We spent an inordinate amount of time on it, no less than 10 minutes, almost 15. If you go back and look at the videotape, which is available at flaconstitution.com, you can rewatch that part of the lecture if you would like. It was at the beginning of that particular lecture. Or you can reread about it in the book in your required materials. Specifically, go to pages 43 through 47. And that was right there at the beginning of chapter 2. So the point we were making there at the beginning of chapter 2, and as I mentioned in the lecture, was a point of Supreme Court exceptionalism. And indeed, that's in all caps in the center of page 44, where it says Supreme Court exceptionalism. Exceptional to what regard? To what extent were they an exception? They were an exception to the ethics requirements that apply to any and all Article 3 federal judges under Article 3 of the U.S. Constitution. Those ethics codes of conduct, as we discussed in the text and in the lecture, apply to any and all federal Article 3 judges except the Supreme Court of the United States and the justices of the Supreme Court of the United States. So that's what we're talking about there when we had judicial ethics and Supreme Court exceptionalism. As we talked about, It says here on page 45 again, the Code of Conduct for United States judges is not a federal statute, but rather a set of ethical guidelines. Then it says here, the code excludes Supreme Court justices. So that's in the middle of page 45. Specifically, it's the third full paragraph. And then that's mentioned again in the fifth full paragraph of page 45. As this article indicates, the book reads, the primary source of federal judicial ethics, the Code of Conduct for United States judges, excludes the justices of the United States Supreme Court. And that's why the correct answer was D, where it says the Code of Conduct for United States judges excludes the justices of the Supreme Court of the United States. So that correct answer was taken not only from the lecture that we discussed, but verbatim from two separate parts, two separate sentences in your text. So it's certainly something you could have gotten right. Also, when we talked about it in the lecture, we stopped and we opened it up for discussion. And there were at least 3 of you from the audience who gave me some feedback as to whether you thought it was a good idea or a bad idea for there to be exceptionalism, to exclude the justices of the United States Supreme Court from the Code of Conduct for United States justices. So there was an open discussion about that. So please don't think this was something that was stuck in a footnote somewhere that you couldn't notice, or that wasn't mentioned in the lecture, or that was only briefly covered in the lecture. Quite the contrary. It was all caps, centered, bold, highlighted, repeated in the text, and then it was highlighted, lectured upon, became part of a class discussion. Some students mentioned it, I mentioned it, a lot of detail. So that's why the answer was D. So now we skip question 2. We didn't include that one on the grading, and we go to question 3. Question 3 read as follows. Which of the following statements accurately describes what may be called a canon of construction of Florida's Constitution? And where would I have gotten that phrase from, canon of construction? Well, if you read the required materials for the class, that was the name of chapter 2. See how chapter 2 is called Canons of Construction of Florida's Constitution? That was the name of chapter 2, and that appears on throughout the 60 pages of chapter 2, right there at the top of every page. So hopefully that was a phrase you were familiar with. But if for whatever reason you chose not to meet the requirements of reading the required materials, perhaps you came to my lecture where I spent almost 2 hours talking about the canons of construction, or perhaps you not only skipped the required written materials and didn't attend the required lecture, perhaps you may have gone to the website where the required lecture was recorded for all to view. Either way, if you'd done any of those 3 things, you would have encountered this phrase before, canons of construction, and you would have been familiar with it. So how would you know what was the right answer? And the right answer here, as you can see on the screen, was E, that all of these statements are true. So statement A, where the Florida Constitution expressly provides the manner of doing a thing, it impliedly forbids it being done in a substantially different manner. How would you know that? I mentioned it out loud at the lecture. I had a big slide behind me and it appeared on the slide. Also, in addition, it appears in the text. That's on page 48, where 48 in the second full paragraph, first sentence reads as follows, quote, where the Constitution expressly provides the manner of doing a thing, it impliedly forbids it being done in a substantially different manner. So that was in the required reading. It was on the slides. And the slides, of course, are also available at flaconstitution.com. So and the videos there too. So for whatever reason you didn't read the required readings, and you didn't go to the required lecture, and you didn't watch the video of the required lecture, the slides were also available for download, and it was on the slide. So there was many ways that you could have gotten that one right. B, a finding of unconstitutionality is disfavored. We talked about that with its caveat that that is a general statement, but that there are times, such as when a compelling state interest standard applies, that this may not be true, such as under the First Amendment of the United States Constitution, as we discussed in the lecture. We discussed the exceptions to this general rule, this general canon of construction, that a finding of unconstitutionality is disfavored. And also that's on page 49 of the text. You can see centered and in bold, it's an actual heading that marks a subsection of chapter 2 that then rambles on and on for a couple pages. So that was not buried in a footnote or failed to be mentioned in the lecture. Just quite the contrary. It's centered, it's bold, it's its own subsection, and it's part of that lecture that's available on the videotape. And there were slides that talked about that too. So how do we know that C was correct? C says parts of the Florida Constitution are to be interpreted to yield a consistent whole. And again, we discussed that in the lecture. We had slides that say such a thing. And if you turned to page 60 of the book, again, centered and all bold, its own subsection 5, interpret parts of Florida's Constitution to yield a consistent whole. So that was there. And also there were the case Bailey versus Ponce de Leon Port Authority that gave you an example of that. You can find that in the text. So that's how you would have known that to be true. How did you know letter D to be true? Letter D reads, the words appearing in the text of the Florida Constitution must be given the plain meaning known to the framers or voters at the time they voted upon and enacted the constitutional text at issue. And this was something that I waxed poetic about in class if you attended the lecture, or if you watch the videotape of the lecture that's available at FLAconstitution.com. We talked about how for SCOTUS, the Supreme Court of the United States, whether or not you interpret the federal Constitution to be consistent with the intent of the framers is a political question, but we then talked about how that's not necessarily true for Florida's Constitution. We talked about in our lecture how the canons of construction instruct Florida Supreme Court and all lower Florida state courts to interpret the Florida Constitution consistently with the intent of the voters or the framers. We talked about that in our lecture. But even if you weren't at the lecture or didn't take the time to watch the videotape of the lecture, it was also in the slides, which you could download. But even if you didn't take the time to download that, it was also in the required readings. Specifically, this is page 53 through 59, and it's covered in all 6 of those pages. So it's not some sort of footnote or something. See, there it is, beginning on page 53, bold, part 4 as its own subsection. But most importantly, we gave you not 1, not 2, but 3 case law precedent. Oops, lost my slides there. Come on back, slides. I gave you 3 case law precedent to read. Remember in class, we talked about Florida Department of Revenue versus Leon County. I was doing that funny thing where I would tap the board and it would turn green. Maybe you remember the joke, maybe you don't. Watch the videotape, it's in there. We also talked about Gallant versus Stevens and Graham versus Herodopoulos. We briefed those cases for you in class, gave you the ruling, and we wrote on the board and analyzed them well. So that's how you would have gotten that one right if you happen to have gotten it right. So therefore, the answer was E, because E says all of these statements are true, and indeed they were. So that brings us to our next question. Where am I in a slide? Oh, were my slides off? I'm looking at you, not at the board, but hopefully my slides are in the right place as I make this live video. But anyway, now bringing us to question 5. And see, question 5 was a long one, so I couldn't fit it all on one slide. Here's the question. There's A and B, and there's C, D, and E. But over here, the correct answer, of course, was E. And the question read as follows. Which of the following statements are true regarding the Declaration of Rights in Article 1 of Florida's Constitution? Now, if you remember our first 2 lectures, lecture number 1 and lecture number 2, each was 2 hours long. So this is something I literally spent 4 hours on. But if you remember any of those 4 hours, or if you happen to have looked at the slides from those 4 hours that are available to you at FLAconstitution.com, you would know that one of the premises of this class is that subsidiarity means that local problems sometimes warrant local solutions. That subsidiarity means that states can have their own state constitutions, which in turn can be interpreted differently by that state's highest court. And in those 4 hours of lecture, we gave a plethora of examples. One of our main examples, of course, was the state of Florida and Florida's constitution. And one of the examples we went back to again and again during those 4 hours and during chapter one, if you happen to have read chapter one in the required readings, is how even though the language of Florida's constitution or any state's constitution may be verbatim identical to certain language in the US federal constitution, that does not, NOT, does not require the state's high court to interpret the language of the state's constitution consistently and identically to the way the Supreme Court of the United States interprets the federal constitution. That was one of the main themes that runs through all our lectures and our text. We referred to that premise of a laboratory of democracy, and we looked at Justice Brennan's law review article about that. We looked at various case law precedent talking about that, and we opined that this laboratory of democracy means that the federal rights cannot be denied. Every state must grant every state citizen in America the full panoply of all federal constitutional rights and human rights. But in so doing, can be a laboratory democracy and can interpret their own state constitution, never to contradict the federal constitution, never to grant less rights than under the federal constitution, but within those parameters, within that floor, can grant greater rights to that state's citizens using the state constitution. And we had so many examples of that in our 4 hours of lecture, and many examples in the 62 pages of chapter 1. So hopefully you're able to get this question right. The correct answer was E. We know that which of the following statements are true. We know that statement A is true. Language in Florida's constitution that is identical to language in the U.S. Constitution. Oh, I'm sorry. Which of the following statements are true? The answer was E. None of the statements are true. So the correct answer was E. The first of the statements that was not true is statement A. Language in Florida's constitution that is identical to language in the U.S. Constitution must be interpreted exactly as the language is interpreted in the U.S. Constitution. No, it's not true. Another one that's not true was choice B. Despite the rulings of the United States Supreme Court in United States versus Windsor, and Obergefell versus Hodges, apologize to those folks if I mispronounce their names. Legalizing same-sex marriage, Article 1, Section 27 of Florida's Constitution still says that marriage is the legal union of only one man and one woman, and therefore in Florida, unlike the rest of the United States, same-sex couples are not allowed to marry. And it's that last part of the statement of letter B that is not true. The therefore clause, where it says, therefore, in Florida, unlike the rest of the United States, same-sex couples are not allowed to marry. That makes all of statement B not true. Yes, if we open Florida's constitution, yes, if we go to Article 1, yes, if we go to subsection 27, we will see the quoted language. But the quoted language is unconstitutional. As we talked about in chapter 1 in our 4 hours of lectures regarding chapter 1, the constitution of a state can in itself be unconstitutional under the federal constitution. And letter B here is just such an example of an unconstitutional phrase appearing in a state constitution. The next one that was not true was letter C, which is on my next slide because I couldn't fit them all on one slide. Article 1, Section 2 of Florida's Constitution declares everyone to be equal before the law, quote, except that the ownership, inheritance, disposition, and possession of real property by aliens ineligible for citizenship may be regulated or prohibited by law, quote, and therefore aliens ineligible for citizenship may not own real property in Florida. In 2008, this language that you see quoted was deleted by an amendment to Florida's Constitution. It had existed there for many decades prior. So that part's no longer there. The other reason C is not true is even if it were still there, it would be unconstitutional under the federal Constitution. We can't deny due process of law based on your race. That would be unconstitutional under the federal Constitution. So for those two reasons, C was false. The next one said all of these statements are true under D. And since all of them are false, we can't pick D and have the right answer. We've got to pick E. None of these statements are true. And that's why E was the right answer. Let's move on now to question number 6. Question number 6 talked about stare decisis, which is something not only covered in our written materials and our required text, but was something that we covered at great length in our live lecture. It was also covered in our slides. So perhaps you read the required materials, perhaps you attended the required lecture, perhaps you downloaded the slides from FLAconstitution.com, perhaps you even watched the required lecture on video, which is available on FLAconstitution.com. That's how you would have gotten this right, specifically pages 50 through 53. So again, not a footnote, something well covered in the text, 50 through 53. And again, it was its own subsection. There it is, top of page 50, bold and centered, consider stare decisis. So that's how you would have known about it. And A talks about a case, Hague versus State, which we also talked about in great length in our lecture, and which appears on pages 50 through 52 of the text. And then at the end of pages 50 through 52, the text then has notes and questions to consider about that particular case. And we briefed that case to you in the lecture. We discussed it as a group. Again, wasn't hiding the ball. So A, the correct answer was B, but A said the lesson of Hague versus State is that stare decisis prevents future justices of the Supreme Court from rendering decisions that contradict or overrule prior decisions of the Supreme Court of Florida. B, two forms of stare decisis exist. Rule stare decisis requires that a particular rule or statute must apply in a given case. Wait a minute. It says B. That should say E. Yeah, now it says E. Sorry about the typo. But if you remember my very first slide, let me go back to my very first slide where I had the answer key. Yeah, I had it right in the answer key there. Oh, nope. I had it wrong in the answer key there too. It's times like these I wish these videos weren't live. But you'll forgive me, please. The point of this video is not to confuse you. The point of this video is to help you. So I apologize. Now, let's take a look at the correct answer, shall we? Number 6, the lesson in Hague is that stare decisis. 6, where are you? That stare decisis prevents future justice of the Supreme Court from rendering decisions that contradict or overrule prior decisions of the Supreme Court of Florida. Two forms of stare decisis exist. Rule stare decisis requires that a particular rule or statute must apply to a given type of case, and result stare decisis requires the outcome of today's case to be the same as the outcome in a prior case. There. Letter B. Letter B is your correct answer. Am I going to give you the correct answer? Yes! Letter B was the correct answer. There's not a typo in this slide. Gosh, times like these, I wish I could start over. But as I mentioned in the answer key, in number 1, there it is. Question 6, the correct answer is B. Forgive me for misspeaking. If we go back now, question 2, question 4, question 5, question 6, the correct answer is B. So forgive me, earlier in this video I misspoke. So thank you for forgiving me. Two forms of stare decisis exist. And if you remember in our lecture, I had a slide on the board where I had the two forms of stare decisis side by side, and I compared the one with the other. I literally walked back and forth comparing the two. So hopefully that helped you understand the difference between rule stare decisis that requires a particular rule or statute must apply to a given case, and result stare decisis that requires the outcome of today's case to be the same as the outcome in a prior case. Now, C can't be right because stare decisis is not an ironclad and unwavering rule that the present must always bend to the voice of the past. Indeed, that's exactly the opposite of what we find on page 53, which is part of the excerpt from Hag versus State. Second full paragraph, first sentence, which reads here, moreover, as we have said before, stare decisis is not NOT, not an ironclad and unwavering rule that the present always must bend to the voice of the past. So that made C the wrong choice. B was the correct answer. Let's see, how many of you got that one right? 67% of you got that one right. So the vast majority of you did. So let's move on now to question 7. Here in question 7 is the opposite. The vast majority of you got it wrong. 56% of you chose A, which was not the right answer. The correct answer for question 7 is E. And this was the Judge Hababrew lengthy fact pattern. It was the longest fact pattern of the 9 graded questions. I hope that wasn't the reason why it was so difficult to get it right. Let me read through the fact pattern, which this lengthy fact pattern I didn't cut and paste into the slide because it would have never fit. But here's where we go. Question 7 reads as follows. After Florida's governor announces his intention to appoint Florida Circuit Court Judge Hababrew to become a new justice of the Supreme Court of the state of Florida, Hababrew becomes the subject of 2 controversial news stories. A Florida newspaper called Twix Left Side prints this story. Haverbrew's former high school classmate Avenatti remembers Hababrew drinking excessive amounts of beer back when Hababrew was in high school. Next, another Florida newspaper called Twix Right Side prints this story. Avenatti is a partisan political operative for the political left party with an agenda to keep Hababrew off of Florida's Supreme Court. Despite the controversy, Florida's governor appoints Hababrew anyway. After Hababrew is sworn in as a justice of Florida's Supreme Court, Hababrew says negative things about the political left party, including, quote, what goes around comes around, quote. Both Twix Left Side and Twix Right Side run stories on their opinion pages debating whether these statements mean that Hababrew is threatening to rule in a partisan fashion when he presides over cases as a justice of Florida's Supreme Court. If, thereafter, Justice Haverbrew's rulings on the Supreme Court of the state of Florida appear to show a partisan bias or political agenda, what can litigants before Florida's Supreme Court who are adversely affected by a ruling involving Justice Hababrew do? And how would you know the answer to this fact pattern? It is because you attended my lecture that covered Chapter 2 and or you read the first 5 pages of Chapter 2, where there was a focus on those 5 pages and a focus during my lecture as to whether or not there was anything that prevents justices of Florida Supreme Court or judges of any Florida state court from ruling in a partisan fashion. We opened this discussion in the book and in our lecture by looking at 2 particular surveys which seem to indicate that non-lawyers in America in recent times have come to the conclusion that they think, rightly or wrongly, they think that the Supreme Court of the United States is as political and is as partisan as the U.S. Congress. These surveys, if they're correct, suggests that the American public think that the Supreme Court of the United States is a political body. Putting aside whether or not that's right or that's wrong, that opened our discussion as to whether or not we could prevent such a thing on a state level under a state constitution. More specifically, we looked at whether the state of Florida under Florida's constitution has prevented such a thing. And the answer we came to, both on pages 45 through 47 of our required readings and in our lecture, is that there wasn't something that prevents it. Specifically, if you look on page 46, second full paragraph, final sentence, it read in this way: but to date, no case law precedent disciplines or punishes a judge for interpreting the Constitution of the state of Florida in a partisan fashion. And we lamented in our lecture whether that was a good thing or a bad thing. So with that in mind, how did we know that the correct answer was E? None of the above. It was from that lecture and from this required reading. So choice A was that you could obtain relief, which is not true, under a plethora of Florida case law precedent, which you just read the quote from the book. No such case law exists. So that's not correct. B said to obtain relief because Florida Supreme Court justices are not, and this is false, are not subject to the same Florida ethics rules as lower court justices. Remember, in the same written material pages and in the same lecture, we discussed how there was exceptionalism for the Supreme Court of the United States, but there was not exceptionalism for the justices of the Supreme Court of the state of Florida. Indeed, we talked about how the justices of the Supreme Court of the state of Florida are subject to the same canons of judicial ethics that all state court justices are subject to in the state of Florida. So we covered that in the text and we covered it in the lecture. So hopefully you knew it for the exam. So that's why the correct answer was none of the above. C says you can obtain relief, which, as we just pointed out, you can't. So this part about the Florida governor agreeing or not agreeing doesn't make this a correct answer because it's wrong. You can't obtain relief. So therefore, the correct answer was E, none of the above. That brings us, that was one where a lot of people got it wrong. But that brings us to the next question, question 8, where literally every single one of you got it right. So I won't spend a lot of time there. The question here was the text of the U.S. Constitution says one thing, the text of Florida's Constitution says the opposite. Which prevails? Everybody got it right. Correct answer was B. And really, the knowledge you needed for question 8, which was covered in chapter 1 of our text and in our first 4 hours of lecture in our class, that's the same knowledge that would have given you the correct answer for question 9. Here in question 9, we ask, the text of the U.S. Constitution is silent on the issue. The Supreme Court of the United States renders an opinion on the issue. The text of Florida's Constitution contradicts this opinion of the Supreme Court of the United States. Which prevails? And the answer is B, the opinion of the Supreme Court of the United States. And that was the lesson of federalism, of the supremacy clause, of the fact that the Supreme Court of the United States is the highest court in the land, the fact that each individual state calls one of its courts, most do, a Supreme Court under its constitution of the state constitution. That doesn't mean that it outranks the United States Supreme Court. So hopefully you're aware that even if a state chooses to call its state high court a Supreme Court, like we call ours the Supreme Court of the state of Florida, that declaration in the state constitution doesn't outrank the federal constitution and its declaration that the Supreme Court of the United States is supreme. Hopefully that's something you understand and understand well. So that made question B correct. Question A obviously can't be correct. And C, D, and E, I tried to give you some misleading caveats, this, that, or the other thing, none of which applied under the facts of this question. So remember, Supreme Court of the United States, SCOTUS, that is the highest court of the land. That brings us to the last graded question on the test. This was question 10. The correct answer was A. And again, I think the knowledge from question 8, which all of you got right, and question 9, which most of you got right, would give you enough to get question 10 right. But also, there was an example that I referenced in my lecture and that appears in the written materials, the required readings from the text, that should have given you the answer here too, even though I tweaked the facts in just the slightest way. The question was, Floridians amend the text of Florida's constitution to state that interest rates in Florida in excess of 10% are unenforceable. Does Florida's constitution say that? No. But there are states that do have usury laws in their state constitution. And if you read the required portions of the text in chapter 1, we talked about just such a state. The U.S. Congress passes a law stating that interest rates in Florida up to 12% are enforceable. Two Floridians make a contract to lend and borrow money at an 11% rate. Their contract is, and the correct answer is, enforceable. But wait a minute. The state constitution said no, unenforceable. But an act of Congress says it is enforceable up to 12%. So under those principles of federalism that we discussed in those first 4 hours of our class and in chapter 1 of our written materials, we know that federal preempts state in this instance. And such an example appears on pages 14 and 15 of this book. Here in 14 and 15, I quote to you verbatim from the congressional record, and I told the story in the lecture about how this particular state, Arkansas, during this particular time in the 1970s, you remember this from the lecture, you can watch it on the videotape on flaconstitution.com if you've forgotten. But during that particular time in the 1970s, the Arkansas state constitution had a usury rate so low that banks were simply not writing mortgages anymore. It was impossible to buy a house with a mortgage in the state of Arkansas because any bank who obeyed that usury law would do so at a loss, could not make a profit. You can amend the state constitution, but it was an arduous task at that time to amend the Arkansas state constitution. It was quicker and easier to have Congress pass a law, and that is what the Arkansas congressmen did in the U.S. Constitution. So there they were, the congressmen representing Arkansas, sworn to uphold the Constitution of the state of Arkansas, but yet went to the U.S. Congress deliberately, knowingly, and got the U.S. Congress to pass a federal statute that would then nullify part of the Arkansas state constitution by preempting it. That can be done. And that was one of the important lessons of the laboratory of democracy, that our federal rights serve as a safety net. They are the floor below which no state can sink. You remember I literally jumped up and down on the floor for you during the lecture to illustrate that no matter how heavy I might be, and I'm probably heavier than I should be, I can't crash through that floor, just like no matter how weighty the state's law might be. It might be in the state administrative code, or greater yet, might be a state statute, or greater yet, might be a provision in the state constitution. No matter how weighty that state law is, it cannot crash below, cannot sink below the floor of the full panoply of federal rights. Even if the source of that rights might not be the text of the federal constitution, might not be in an opinion of the Supreme Court of the United States, it might be an act of the U.S. Congress, it might be in the USC, United States Code, but still, that's part of the floor. So that's how you could have gotten what some of your classmates did get, and that is a perfect score on the midterm exam. I know some of you did not, but I'm still rooting for you. This is only 20% of your grade. You can do this. You can pass this class with flying colors. You can take the knowledge that this class offers, take it with you into practice, and put it into good practical use. But in order to do so, you're going to have to read the required written materials. You're going to have to attend the required lectures. You're going to have to pay attention during those lectures. And if I'm not keeping your attention by jumping up and down on the floor and pointing to the big slides. I apologize, but it's videotaped, so you can watch it again if you have to. Likewise, if the book didn't catch your attention the first time you read it, you can read it again and again if you need to. You can look at my slides. You can download them from FLAconstitution.com. You can do this. You can work hard. You can get a perfect score, just like some of your classmates did. You can earn that Juris Doctorate degree. You can become a lawyer. And if you want to, you can represent your clients well and fight for justice. That's the end of this tape. Gotta get up now and turn it off. I wish you well. Thank you for your attention and time.